intervention in Libya, which of course we've seen in the last few months some obvious momentous events in the Arab world, with revolutions, or at least partial revolutions so far, in Egypt and Tunisia, and then unfinished revolutions perhaps in Yemen, and ongoing protests in Syria. Bahrain, things have gotten, I think, a lot worse for the protesters. We've seen that the protesters, at least at the moment, have been fairly effectively shut down. And I would refer any of you to have a look at our foreign correspondent from last night, which had a special episode on Bahrain, which I presume would probably be on ABC, I think, if you missed it last night. But of course, the country that we're talking about tonight is Libya, where peaceful protests did start in the middle of February, but they fairly quickly morphed into armed protest or armed rebellion, and have since, that's now erupted into really an international war between Colonel Gaddafi and the rebels, and the international forces on behalf of NATO, authorised by the United Nations, are also involved. And so tonight's forum is to talk about those events. And we have with us tonight, we're very grateful to have three excellent speakers. And I should first of all say who I am. I'm not one of the excellent speakers, but my name is Sarah Joseph. I'm the director of the Caston Centre. I apologise for the noise outside. We're doing the best we can to try and soundproof this place. But I'm not one of the speakers. I'm the chair tonight. I will introduce all three of our speakers in the order in which they'll talk, and then we will have time for questions. But I think it's easiest to introduce all three rather than me jump up three times. So our first speaker tonight, who will be taking a perspective looking at international law matters to do with the Libyan intervention, is Professor Don Rothwell from ANU in Canberra, who is a professor of international law and has been at ANU since July 2006. And he has many research focuses, including the law of the sea, and of relevance tonight, the use of force. He has published 14 books and over 150 book chapters, and he's acted as a consultant to many expert groups such as the UNEP and the UNDP, the Australian Government, and he's acted as an advisor to the Australian Conservation Foundation and Greenpeace. He is also an active media commentator. Our second speaker tonight is my colleague from Monash University and an associate of the Caston Centre, and that is Associate Professor Gideon Boas, who will also be taking an international law perspective, focusing also on international criminal law aspects of events in Libya. Gideon is an associate professor at Monash. He's an expert in international criminal law and international law. Prior to coming to Monash, he was a senior legal officer at the International Criminal Tribunal for Yugoslavia, where he was a senior advisor to the trial chamber in the Milosevic case, and he's also written a book on that case, and his PhD was about that case. He is regularly consulted by the media for his views on international law, politics and criminal justice. And our third speaker tonight, who will be taking a less legal perspective and more of a political science perspective, is Jeff Sparrow, Dr. Jeff Sparrow, who is an Australian writer, editor and activist, who is currently working as a research fellow at Victoria University, and he's also the editor of the literary journal Overland. Jeff has authored a number of books, most recently Killing, Misadventures in Violence, which is a study in social and psychological consequences of executions, combat and animal slaughter. Jeff is a regular contributor to many publications, including Crikey, New Matilda and The Drum. And he will be our third speaker tonight before we have questions. So please welcome our first speaker, Professor Rothwell.
Good evening, everyone, and thanks so much, Sarah, for that introduction. It's a great pleasure for me to be here in Melbourne and to be speaking on these issues this evening. Just wait till we get the PowerPoint set up. Thanks. Since the unrest developed in Libya in early February and the Gaddafi regime commenced attacks upon the civilian population in the middle of that month, as we know, the international community has been faced, in my view, with a series of clear choices. It could either sit back and watch those events unfold, no doubt from time to time offering some sideline commentary, or it could elect to actually give real effect to a doctrine that has been much discussed in international circles for the past decade. Eventually, first with Security Council Resolution 1970, which was adopted on 26 February, and then with Security Council Resolution 1973, which was adopted on the 17th of March, the Council acted with uncharacteristic speed and agreement to really give effect for the first time to the responsibility to protect doctrine. In doing so, I believe that the Security Council has paved the way for a more proactive response to international crises when civilian lives are at risk and mass atrocity crimes are being committed. To understand what has occurred in Libya, it's important to have some context to the recent history of military intervention undertaken for humanitarian causes. Since the adoption of the United Nations Charter in 1945, there has been an ongoing debate as to whether there exists a right for a single state or for a group of states acting collectively to undertake so-called humanitarian intervention when faced with an overwhelming state-induced humanitarian catastrophe in a neighbouring state. And indeed there have been a number of examples of such actions over the first 50-odd years of the UN. India's 1971 intervention in Pakistan, Vietnam's 1978 intervention in Cambodia, and Tanzania's 1979 intervention in Uganda are all examples of this so-called humanitarian intervention. As it developed during this period, it could be characterised as the following. The justifiable use of force for the purpose of protecting the inhabitants of another state from treatment so arbitrary and persistently abusive as to exceed the limits which the sovereign is presumed to act with reason and justice. Now, one of the features of that definition that's on the slide is it talks about the justifiable use of force. However, one of the common critiques of humanitarian intervention is how can such an intervention be justifiable consistent with the provisions of the UN Charter? And indeed, in the three examples that I just referred to, there was no UN authorisation, there was no UN mandate for the actions that were taken. I would suggest that there is flimsy grounds to justify interventions in those cases based on self-defence, and no matter how honourable the intentions may well have been of the intervening states, it's certainly strongly arguable that there was a direct violation of Article 2.4 of the UN Charter. 1999 then becomes quite a pivotal year in terms of understanding the way in which this debate about humanitarian intervention began to develop. That was the year that NATO took the step of militarily intervening in Kosovo, notwithstanding the fact that the Security Council was deadlocked and unwilling to authorise and provide a mandate for NATO or other forces to intervene in that situation. Nevertheless, at the end of the day, the general consensus was that whilst the NATO intervention in Kosovo was illegal, it was certainly considered to be legitimate given the humanitarian crisis occurring there at that time. Also in 1999, you will recall that Australia led the Interfet military intervention in East Timor. Though technically Indonesia accepted the UN mandate and authorised the Interfet intervention, I think you could also characterise that action as one undertaken for humanitarian purposes. And indeed, it was undertaken in the face of a situation where a state was unwilling or unable to protect the civilian population following the UN-administered vote in that territory. Notwithstanding what you might call the successes of some of these interventions, both in Kosovo and East Timor, and the lives that were saved as a result of those actions, the attempt by some governments, including Australia in 2003, to suggest that the Iraq military campaign was somehow justified on humanitarian grounds, in my view, did more harm than good in terms of advancing this argument as to how humanitarian intervention might be reconceptualised in the 21st century. Nevertheless, notwithstanding the controversies about the Iraqi intervention in 2003, in my view, coalition military operations in Libya cannot be characterised as an act of aggression in violation of international law, but rather they are clearly carefully tailored to achieve humanitarian objectives consistent with the responsibility to protect doctrine. And the most important element of that doctrine and the way that it's being operationalised at the moment is, of course, the cessation of government-sponsored and government-backed attacks against the Libyan population. Likewise, regime change is not the stated goal under the UN mandate. If Colonel Gaddafi's regime so happens to be toppled as a result of the opportunities presented to opposition forces as a result of the imposition of a no-fly zone, then I think it's probably unlikely that the international community will be too concerned. And indeed, the recent joint statement by President Obama, Sarkozy and Prime Minister Cameron certainly confirms that point of view. In the short term, however, the goal remains the effective implementation of Security Council Resolution 1973, and this point has been consistently restated by the NATO Secretary-General and as Rasmussen as recently as 4 days ago. The implementation of the Security Council resolution, of course, commenced with British, French and US forces launching air and sea-based strikes against Libyan military targets, and as of today, a total of 34 countries are now engaged in the military operations under NATO command, with a Canadian general acting as the commander of NATO forces. By coincidence, the coalition forces commenced their campaign in Libya precisely 8 years to the day since the 2003 US-led military intervention in Iraq. Now, as you're probably all aware, that action was widely condemned as being illegal and unnecessary, especially following the failure to locate Iraq's alleged stash of weapons of mass destruction. Whilst initially a military success, the Iraqi campaign became bogged down in combating widespread sectarian violence following the fall of Saddam Hussein's Ba'ath regime and state reconstruction. However, I would suggest to you that much has now changed in the international community since those events of 2003. In 2003, the Security Council refused to pass a resolution allowing for military intervention in Iraq. Yet in the case of Libya, the Council first adopted Resolution 1970 on 26 February. This resolution was remarkable for a number of reasons. First, it reflected a quite rapid response by the Security Council to the growing Libyan crisis, which was all the more remarkable because it was adopted unanimously by all 15 members of the Council. Second, the Council agreed to refer the situation in Libya to the prosecutor of the International Criminal Court for investigation as to whether international crimes have been committed by the Gaddafi regime. This was only the second time that the Council had undertaken such a referral, and the upshot of this development, no doubt as my colleague will refer to in his presentation, is that members of the Libyan regime may in the future find themselves before the ICC on charges of international crimes, including crimes against humanity. Third, the Security Council in Resolution 1970 agreed to a number of sanctions against the Libyan regime, including the imposition of an arms embargo, travel constraints on Colonel Gaddafi and members of his family, and the freezing of Libyan overseas assets. Resolution 1970 was followed up, as you know, 19 days later with Resolution 1973 authorising the use of military force. Here, in my view, the game changer was quite clearly the doctrine of responsibility to protect, or otherwise known as R2P. First actively debated in the wake of the 1999 Kosovo intervention, in 2001 the former Australian Foreign Minister Gareth Evans was a pivotal contributor to a report by the International Commission on Intervention in State Sovereignty that canvassed ways in which the international community had a responsibility to protect civilian populations from mass atrocity crimes. Mindful of the failure of the UN to adequately respond to situations involving such crimes in the former Yugoslavia and Rwanda during the 1990s, Evans actively promoted R2P in UN corridors of power and in world capitals. The doctrine eventually won significant support at the 2005 World Summit of the UN General Assembly. Whilst this represented a fairly rapid development of a new international consensus in responding to state-induced crimes against humanity and acts of genocide, a key issue always remained as to how it would actually be implemented. In other words, how would it be militarily operationalised? Especially also if there was a need to secure a Security Council mandate to provide a basis for such an operation to take place. Over the past 2 months, the international response to the Libyan crisis really has been couched in the language of R2P, including not only from the UN Secretary-General Ban Ki-moon, but from various heads of state and foreign ministers, including, of course, Australia's Foreign Minister Kevin Rudd. R2P language is deeply embedded in Resolution 1973, both in terms of its scope and also in terms of its limitations. The focus is upon humanitarian action designed to protect civilians and civilian-populated areas under threat of attack from the Libyan regime. Crucial to the success of coalition military operations is that, and I quote, all necessary measures, end quote, may be taken to achieve those ends. The only military limitation is, and I quote again, that a foreign occupation force of any form on any part of Libyan territory is not permissible. A ban on all flights in Libyan airspace is imposed, creating the much sought-after no-fly zone. An arms embargo is also reimposed, permitting coalition forces to interdict vessels on the high seas suspected of running arms, including transportation of mercenaries to resupply the Gaddafi regime. Now, there's been an inevitable and I think quite necessary debate as to what exactly the extent is of the UN mandate in Libya. On 14 April, the NATO Secretary-General, Anders Rasmussen, stated that NATO foreign ministers had sought to identify their clear expression of unity and resolve and reconfirmed their military objectives as follows. And this is a quote from what Rasmussen said just in the last week. He said as follows, "We are committed to provide all necessary forces and maximum operational flexibility within our mandate. A high operational tempo against legitimate targets will be maintained and we will exert this pressure as long as necessary and until the following objectives are obtained. 1. All attacks against civilians and civilian populated areas have ended. 2. That the regime has verifiably withdrawn to bases all military forces, including snipers, mercenaries and other paramilitary forces, including from all populated areas they have forcibly entered, occupied or besieged throughout all of Libya. And then 3, the regime must permit immediate, full, safe and unhindered humanitarian access to all the people in Libya in need of assistance." Now, much debate really remains as to what 1973 permits, especially as to whether it permits so-called boots on the ground. In other words, is the wording of the resolution broad enough to permit the intervention of ground forces? On 15 April, Rasmussen indicated that NATO had not discussed this matter to date, had not given consideration to the seeking an adjustment of the UN mandate, but that in any event, the view was that such action was not mandated under the resolution. Now, legally, I think that this view is contestable. Resolution 1973, as you can see, expressly excludes a foreign occupation force of any form on any part of Libyan territory. This reference to an occupation force, I believe, must be read in the context of international law, especially the 4th Geneva Convention, which directly deals with military occupation. Intervention in Libya by foreign forces seeking to restore international peace and security, acting under an R2P mandate of protecting the civilian population, would not prima facie be an occupation force. This would especially be the case if they were seeking to act in concert with Libyan opposition forces or the provisional rebel government, which is currently called the National Transitional Council. While politically and symbolically there is understandably reluctance on the part of NATO, and especially key NATO members such as the United States, to be seen in any way to be participating in what may be portrayed as an invasion of Libya, the fact is that they already have ground forces deployed on a case-by-case basis. British Special Forces have been deployed in Libya from time to time over the last 3 weeks. And overnight, the British Foreign Secretary, William Hague, confirmed that British and French military officers would be sent to Benghazi to advise rebels on intelligence gathering, logistics and communications. Whilst there is understandable nervousness about so-called mission creep, the deployment of these forces, certainly in my view, does not violate the UN mandate. There is much about the international community's response to the Libyan crisis to applaud, in my view. After considered debate, R2P has been operationalised. It is not a liberal doctrine promoting the international use of force, but rather one in which force is only to be used as a last resort in the face of civilian populations being at risk or having been subject to the worst of international crimes, being crimes against humanity, ethnic cleansing, genocide and grave war crimes. Only in these cases, where a sovereign state refuses to meet its basic obligations to protect its civilian population, will R2P be activated. In the case of Libya, the Security Council has taken some brave steps. It has sought to deploy a number of the tools at its disposal to restore international peace and security, to protect civilians, and to bring those responsible for mass atrocity crimes to account. Perhaps finally, the United Nations is beginning to act decisively in the manner that was anticipated for it during the 1945 San Francisco Conference, when at that time, of course, the international community was united in its efforts to bring about the end of the Third Reich.
Actually had a bet with myself after Sarah spoke that she wouldn't be able to stay quiet for the entirety of the 3 speakers, and I won. So I'll collect my payment. You weren't aware of that, but I'll collect it later. I would like to draw on some threads of what Don was speaking about in his presentation. Hopefully they're not too loose and anarchic and they tie together in some way. But there are a few issues that have emerged out of the military incursion in Libya that I think raise some fundamental questions. And the first of these is, what does the use of force in Libya signal in terms of a moral and legal framework of international law? I think the first point that needs to be made here is that the use of force against Libya is an extreme violation of the sovereignty of that state. And I don't think that we should shy away from that. It's hard to think of a more extreme incursion on the sovereignty of a state than bombing it to smithereens. Now, having said that, of course, it's a perfectly legal violation of the sovereignty of that state. And as Don pointed out, the United Nations Security Council Resolution 1973 clearly authorises the use of force on the part of the international community, triggering Chapter 7 and the responsibility of the Security Council to maintain or restore international peace and security. So clearly there is legal merit that justifies the use of force against Libya in these circumstances. But as a legitimate use of force, it raises, it seems to me, an awful lot of questions. First of all, why Libya? What is so special about what had happened in Libya that required the international community to respond in the way that it has? There were repressions, there were murders, there was widespread human rights abuses on the part of the Gaddafi regime. No question, but so too have there been those things elsewhere in other countries where the international community has not responded. Was what was happening in Libya more extreme than, say, for example, what was happening in Yemen or Bahrain or Syria? I think a reasonable response to that is probably yes. Was it worse than, for example, the long-term crippling repression and human rights regime wielded by Mugabe's government in Zimbabwe, or the genocide or crimes against humanity committed by al-Bashir's government in Sudan? Was it worse than the Congo or the Ivory Coast, or a whole range of other examples that we might mention? And it seems to me, and perhaps it's a little cynical to say this, that one of the key reasons the international community was prepared or indeed eager to act in Libya was Gaddafi himself. I suspect that there are a number of long-term scores that are left to settle between the West and Gaddafi, and that certainly would have been one motivating factor in the minds of some of the states willing to take action. The second question is, what relevance does the military action in Libya have for broader questions of international law relating to the use of force? And by those broader questions, I mean the doctrines that Don referred to, the responsibility to protect doctrine, and the doctrine, if it is such a thing, of humanitarian intervention. Both of these doctrines purport to permit the use of force, albeit in differently defined or perhaps loosely and changeably defined circumstances. The responsibility to protect doctrine seems to require Security Council authorisation for the use of force, and a range of other measures being a preferred option before force is resorted to. Humanitarian intervention, on the other hand, clearly occurs outside of Security Council authorisation, and the leading example of that, and its modern manifestation, as Don explained, was Kosovo, and I want to return to Kosovo in the context of this discussion later. Now, debate leading up to the use of force in Libya and its relationship with these doctrines, I think, suggests a broader message for traditional conceptions of sovereignty here. The question that probably needs to be asked is, does this trend towards intervention, selective as it may be, signal a demise in the meaning of sovereignty, the long-cherished foundation of international law? In one sense, the Libya scenario might be viewed as a battle between sovereignty on the one hand and perhaps idealism, let's call it idealism, on the other. It is true that while sanctioned by a Security Council resolution, it is an example of this trend away from formalism or legalism in international law towards a regime built more on the concept of legitimacy, a trend that for some is disturbing. The idea that the international community could act in response to egregious treatment by a government of its own people is not a new concept. At least as far back as 1915, the Russian, British and French governments issued a joint declaration threatening the Young Turk government in the Ottoman Empire of criminal sanctions against members of the government for its now widely referred to as genocide against the Christian Armenian population. And anyway, why should dictators and despots who bring death and atrocity upon their own people be protected by the sovereign rights afforded their country? Gaddafi is precisely an example of conduct. Gaddafi's conduct is precisely an example of what inspires contempt for the artifice of sovereignty. The danger, I suppose, in hastily throwing out traditional concepts of international law, such as sovereignty, is that the balance of power may not always lie where we might like it to. For example, what if Russia and China were determining what intervention was appropriate and when? I suspect for a start a blind eye would have been turned to Milosevic's Serbia and its actions in Kosovo, that perhaps intervention in Georgia to promote independence of Abkhazia and South Ossetia would have been on the agenda, as perhaps was some form of action against Taiwan to bring it firmly back into the fold of Chinese sovereignty. Certainly no action against Gaddafi. The inevitable scepticism over the motivation of major powers for such intervention, I think, is unfortunate, because I do think that clearly at times it's undertaken, at least in part, out of a genuine moral outrage. I suppose my point is that Libya exposes the growing disquiet with traditional and entrenched rules relating to sovereignty, which have already been pulled apart or at least exposed by actions and by movements within the human rights and international criminal justice regimes. And the dangers inherent, I think, in turning international law into a system of moral policing is one that we need to contemplate when we talk about military incursions of the nature of Libya. I think the second point, the second major theme that is worth exploring, or that I want to explore tonight, relates to some of the practical problems associated with the Libyan situation. Don referred to and explained the Security Council mandates under resolutions 1970 and 73. But how far is the West actually prepared to go here? I think I agree with Don. I think that there is most certainly scope to consider the use of forces on the ground, despite the fact that the drafting of the resolution was, I think, designed to suggest otherwise. But there's certainly no will within the international community for this to occur. I read pre-resolution articles by people like Wesley Clark, who's the former head of NATO, by our own former Foreign Minister Gareth Evans, and numerous others, about how this intervention is different. This intervention, unlike Vietnam, unlike Somalia, unlike Afghanistan, this is containable. We can do this. This is a defined action. We'll go in, we'll set up no-fly zones, we'll bomb Gaddafi's forces, we'll take out major assets, and then the regime will take over and all will be well. It seemed to me, however, from the start, and absolutely nothing has changed my view of this, that all the same sorts of problems would plague the attacking alliance. The fact is that if Gaddafi digs in and a deal for his departure cannot be broken, a ground war is the only option to oust him. And I don't see anybody bringing this enthusiasm to take this on, even, as was suggested by many who supported the Security Council initially, that somebody within the Arab League of Nations would happily take this on. I haven't seen them lining up. Now we hear of the impending prospect of arming the rebels with heavy weapons. What happens if that works? What happens if the rebels win and a new leader is installed? And what happens if that new leader is just as or less palatable than Gaddafi himself? What if Libya becomes the next Al-Qaeda breeding ground? I would have thought that Alain Juppé's reference to a wave of great revolutions sweeping the Middle East and North Africa that would change the course of history was a great candidate for a future foot-in-mouth award, when these great revolutions turn into a series of great rogue regimes. Of course, in the meantime, the airstrikes and any other military intervention has the prospect of causing other considerable practical problems, including, of course, our old friend collateral damage and more civilian deaths. Look at Kosovo as an example. What was considered to be a very fine set of military attacks with a defined mandate, a technologically advanced armed force undertaking attacks with pinpoint precision, in fact revealed clear excesses and misjudgments on the part of NATO and NATO countries involved in those attacks. And those countries and those involved in those armed attacks were only saved from the prospect of war crimes prosecutions by the fact that NATO was able to bully the then ICTY prosecutor Louise Arbour from making appropriate findings in an investigation that she and her office undertook at the time. The fact is that bombings of Kosovar Albanian civilian refugee columns occurred. The Serb TV tower was bombed, probably quite inappropriately. The Chinese embassy was bombed, you might recall. Oh, and I do vaguely recall reference to the widespread use of cluster bombs and its indiscriminate effect. And that does ring in my head after reading about the moral condemnation of Gaddafi's own forces using cluster munitions, how quickly we forget. The fact is that the prosecutor's report in relation to NATO's conduct in Kosovo most certainly raised a prima facie case for further investigations and possibly indictment. And only one member of that panel, William Benrick, had the courage to say so. And doesn't the failure of the West to hold itself accountable when it's in the wrong serve to reinforce moral confusion surrounding interventions like Kosovo or indeed Libya? Recent examples of Afghanistan and Iraq alone show how the more entrenched foreign powers become in a war, the greater and more complex these issues are likely to become. A final word on war crimes charges against Gaddafi and the situation in Libya. And again, I know I'm sounding like a West basher here, but I don't mean to. I just have to note, the first thing that comes to my mind when I think about the referral of Libya to the International Criminal Court is that the US was one of the great proponents of this referral. In the same way as one of the great proponents of the referral of the situation in Sudan, the only other Security Council referral to the International Criminal Court. Now, remind me if I'm wrong, but isn't the US the arch enemy of the International Criminal Court? The US delegation, led by the long-serving Yugoslav Tribunal judge and for many years president of the Yugoslav Tribunal, Theodore Meron, said no to an ICC in Rome in 1998 and went about, those of you who may have been there or read something about it, bullying other delegations into saying no also. The Clinton government ratified at the last moment, but of course as soon as Bush took power, he withdrew ratification very quickly and went to war on the ICC. You might recall that he passed the American Service Members Act, which authorised, among other things, the use of force against the sovereign territory of the Netherlands to extract any US citizens that had been transferred to the court's jurisdiction. It also used its power within the Security Council to bully other states into not, or into a waiver of jurisdiction in relation to any US citizens that might be implicated in the court's investigations. Now, while the Obama administration has certainly softened its position on the ICC, it has never ratified the statute and is not a member of that court. So as the US stands as the world's moral soldier, I think it's worth considering the historical and moral context within which these circumstances take place. Now, this is by no means to suggest that a blind eye should be turned to what is happening in Libya. The ICC can, and I think will, play an important role, both in areas of accountability, in the potential prosecutions, but also in the process of deterrence. I'm a firm believer that international war crimes trials are working to deter leaders from engaging, perhaps in particular kinds of excesses in their repression of their own and other peoples. As to whether Gaddafi would be found guilty or not, I don't think that really matters a great deal. I know I wasted 4.5 years of my life on the Milosevic trial, and I should feel differently, but I think the greatest role that international war crimes prosecutions has in relation to leaders, to political leaders in particular, is the process of stigmatising them, and particularly from removing them from the sphere of influence within a country. I remember when Milosevic was indicted and particularly arrested, there was enormous anxiety that that would serve only to make him a martyr to the Serb people and would entrench nationalist objectives by many within the country. Quite the opposite. Once you take a person like Milosevic or a person like Saddam or Taylor, less so, certainly like Gaddafi, out of their sphere of influence and put them in a courtroom and listen to them rant and rave and try and get used to the idea of being surrounded by armed guards and eating very average food and being in a detention facility, they begin to look stupid and ridiculous very quickly. And their rants, which you can hear from Gaddafi consistently, become pathetic. And I think the view from within a country of a leader like that is such that this stigmatises then the regime and what they stood for. And I know that in Serbia, I think the removal of Milosevic certainly assisted in that country's ability to move forward, albeit slowly. Of course, Gaddafi's mouth has been running off, as all of these dictators' mouths do. They can't help themselves. It's the same sort of thing said all the time. I suppose in Gaddafi's case, even worse, referring to his opponents as cockroaches, which is the language of genocidal regimes, by the way, and saying that he'll seek out and destroy every last one of them. If I was the prosecutor, I'd be rubbing my hands together, quite frankly. If I was in the ICC, I'd be desperately wanting to get my hands on Gaddafi, because I think you can probably convict him on the basis of his own public statements alone. But I think the real question remains whether there's any purchase in an International Criminal Court investigation and indictment. As we've seen in Sudan, an internationally reviled president charged with genocide has been able to remain in power and politically active. In fact, many have argued that indicting al-Bashir was counterproductive. Certainly, once that took place, he made it very difficult for the UN and other humanitarian agencies to operate in Sudan, and that certainly had a punishing effect on his own population. My point here is, yes, I would like to see Libya as a situation before the ICC. Yes, I would like to see Gaddafi and many others within his regime, particularly lots of them who are turning their coats now and trying to seek some sort of sanctuary in another country. I'd like to see them indicted and prosecuted and locked up. Absolutely. But if the West is going to do that, if the international community is going to do that, then it needs to see it through. There's no point in indicting Gaddafi, throwing a few bombs, arming some rebels and saying, we really like it. If you manage to extract them and send it to us, we'll prosecute it, but that's about as far as we're going to go, because that could do more damage than good. So the point here is that the International Criminal Court is not an end in itself. The process of international criminal justice, the capacity of war crimes tribunals to serve, to improve the lot of those who have been the victims of these crimes, has to be taken in the context of its political environment. And unless those with the political power are prepared to take action to affect the transfer and trial of these people, then this is really nothing more than lip service and will do more harm than good, as I said. Now, in conclusion, I realise that I've raised a lot of problems and concerns over Libya and about the role of international law in such interventions. But I'm not necessarily against such interventions, nor am I necessarily against a shift in the international legal landscape. Heightened scrutiny of regimes that mistreat their own people is a good thing. Sometimes the use of force is a good thing. The use of force in Libya may well be a good thing. My only real concern is that we have regard for the traditional rules of international law and the effect that such a trend might be having on the protective role that formal traditional rules can play. Thank you.
Thanks very much, Al.